Welcome back to the Politics with Paul podcast, your home for nonpartisan discussion of political science and civics. I am your host, Paul Rader. Today is going to be about the concept of states' rights. Where's the line between state and federal power? One of the most enduring debates throughout American political history has been over this concept of states' rights. And this dividing line between federal power and authority and state power and authority was central to the crafting and ultimate passage of the U.S. Constitution. Yet it's far from a solved issue even 2.5 centuries almost later. And it's woven into almost every policy you can think of, including for immigration, abortion, religious expression, LGBTQ issues. And so if we want to have real, long-lasting solutions for all these matters and more, then we need to come to a better understanding of the divide between federal and state power, why it's important, the development of states' rights philosophy, and the arguments made both for and against states' rights. So, let's first talk about the pros and cons of state powers, because like many things in politics, there are benefits and there are drawbacks. Perhaps the most core part of the argument, besides just political philosophies, is the need for cohesion versus the need for sovereignty. On the one hand, states' rights is beneficial in the case of they're closer to their constituents than the federal government is, and thus they're more knowledgeable about the intricacies of their state's affairs and voters' preferences. It just makes sense to have some level of efficiency or it makes some level of sense to have the states lead certain policies because it's more efficient for them since they are closer to the ground. And also, federal government can and has overstepped its bounds in the past, and so the states need to be able to have some recourse to push back. But, on the other hand, states can also thwart cohesion across the country by trying to pull in a different direction just because it doesn't like certain policies. And it can also be used as an excuse, states' rights could be, to deprive rights and powers of their state's constituents. Federal government and state government are both capable of doing good things and doing bad things. And so states' rights, therefore, has had a checkered history. And the complexity of the issue and the evolution of judicial interpretation of federal versus state power and political incentives have made this a fierce debate. The complexity of the issue because it's not always clear and obvious what is state jurisdiction and what is federal. Yes, there's the 10th Amendment, which we'll get much more into in a minute, says that any powers that don't directly belong to the federal government belong to the states, but there's also other parts of the Constitution that make that a little bit murkier, and Supreme Court interpretations, because the Supreme Court has evolved in its rulings on how to apply constitutional law and federal statutes to the states. And in terms of political incentives, while some people subscribe more fundamentally to states' rights philosophies, and typically these are people who are more conservative, the actual support of it fluctuates amongst both parties depending on who is in power. Because when one party controls federal government, they tend to be much more supportive of federal law guiding the states and saying states should get in line, our people are going to be running the show, and we are the ones who know everything and are going to do everything right. And then the party that's out of power is going to say, well, this is the federal government intruding on states' rights. And both Republicans and Democrats can fall into that way of thinking, and independents who lean one way or another. So there is sometimes a level of inconsistency in the support for states' rights based on whether it's a policy that person or that group or that party want. And of course, inconsistency is very common in politics because people are trying to get their way. And it's not the way that things should be, but it is the way that things are. But nonetheless, we do need to come to a better understanding of this divide between federal and state power so that we can figure out what is the best course of action. And that's not an easy thing to come up with. A lot of people think that they've got it all figured out, but it's really not a simple this thing should be federal, this thing should be state. Yes, in some cases it is that simple, but an overall federal government should be leading or state government should be leading is rarely ever that simple. And so to better understand this debate, we need to go back to the very beginning of this debate. We need to go back to the actual drafting of the Constitution. Following the Revolutionary War, it was not the U.S. Constitution that came into play. It was actually the Articles of Confederation that became our central document regarding the law of the land. And it was crafted deliberately to vest almost all powers with the state governments and establish a weak central government. But glaring weaknesses soon became apparent because all the states wanted to pull in their respective directions, and they had different ideas of what was good policy, and the unifying power of fighting against the British Crown and fighting for independence was no longer there. There was nothing to unite these states. They all, a lot of times, acted more like separate countries than one country as a whole. And to make a long story short, the U.S. Constitution was created to more properly balance power between federal and state governments. The anti-federalists felt that the U.S. government or the U.S. Constitution gave too much power to the federal government at the expense of the states. And one of their main gripes was that there was not a Bill of Rights. Those first 10 amendments, they were not created until a couple of years after. But initially, James Madison and Alexander Hamilton were against a Bill of Rights because that they felt that the Constitution had laid out the only things that the federal government could do. And so they worried that if there was a Bill of Rights, that would imply that federal government powers, or that the federal government had powers that it did not have. And it would suggest that any rights not in the Bill of Rights would be unprotected. And this was actually mostly addressed with the Ninth Amendment, which we'll get into shortly. But that said that any rights not expressly given in the U.S. Constitution was vested within the people. But ultimately, James Madison, despite his worries about a Bill of Rights, he ultimately engineered the process for a Bill of Rights to be added to the Constitution a couple years later as a way to appease anti-federalist sentiment and get the U.S. Constitution ratified, especially in Virginia. And so central to the states' rights debate is the 10th Amendment, which says that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Well, that sounds pretty straightforward, except it's not. This, among other developments, showed that Madison and Hamilton were right to some extent that the Bill of Rights would become an issue in what rights do the people have that they need to have clearly laid out. What powers do the state governments really have? Some people have interpreted the U.S. Constitution to include certain powers within the federal government, and other people have disagreed with those interpretations. And so I want to cite 3 key original constitutional passages, so not ones that deal with amendments to the Constitution, ones that were in the Constitution to begin with, that are also a core part of this debate, not necessarily directly related to states' rights, but would crop up often in debates over states' rights over the course of American history. And the first one is the Necessary and Proper Clause, and this says that the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That's sort of nebulous. What would be considered necessary and proper? Many debates of that over the years. The Privileges and Immunities Clause. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. And so this protects against efforts to discriminate against out-of-state citizens. You have to treat out-of-state citizens like you would if they were native citizens of your state. But what counts under that umbrella? And then lastly, the Supremacy Clause, which says this Constitution and the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. this Constitution and the laws of the United States, which means federal statutes. So which of these federal statutes has constitutionality? And a lot of arguments for states' rights have said that many of these statutes are unconstitutional or they infringe upon state government powers and authority. The U.S. Constitution and federal law supersede any conflicting state laws, yes, but what laws are in conflict? And so, before we get to today's controversies and debates surrounding that, let's talk about how it's developed over time. What are these states' rights controversies and developments that we've seen over the course of history? Because there have been over 235 years of development in the states' rights arena. And if I were to really comprehensively cover it all, there wouldn't be enough time in this podcast. So we're just going to cover several of the really key developments in the states' rights debate. And the first one to talk about in the case of states' rights is the Nullification crisis. So back in 1828, there was a tariff that was passed that implemented a whopping rate of 49%. Tariffs were not a new idea back then, but they had never gone that high before. And they were supported by northern manufacturers as a necessity to protect against British competition and their imports. But consumers and southern planters, who took to naming this the Tariff of Abominations, hated it because they relied heavily on European trade to buy and sell goods. And also there was a financial panic not that long before. They worried that this would trigger potentially another financial issue for the country. And it's just one of those many conflicts between North and South prior to the Civil War. John Quincy Adams, then president, signed the tariff into law, and that was a major reason that he lost re-election in 1828 to Andrew Jackson, who was a Southerner. So, one would think that Andrew Jackson, being a Southerner, would get rid of this tariff or push for getting rid of this tariff because of how much his fellow Southerners hated it. But, surprisingly, he actually declined to do anything about the tariff, even though he was oftentimes somebody who was reluctant to implement. He had a very strict interpretation of the Constitution as to whether the federal government had power or not. But he declined to do anything about this tariff, despite his fellow Southerners being very upset about it. And so an incensed Vice President John C. Calhoun led the charge for what is called nullification, which is a theory that a state could disregard and void any federal law it felt was illegal under the U.S. Constitution. So not just because, we don't like to do it, even though functionally, a lot of times it was simply because that state just didn't like that law because it didn't benefit them. But they had to. Nullification was the idea that, this actually is an unconstitutional law, so we don't have to listen to it. And this triggered a lot of heated discussions and even threatened to spill over into violence. And so Congress, in the attempt to quell Southern resistance, passed the Tariff of 1832, which did lower the tariff, but not considerably, certainly not enough to appease the South. And so the South Carolina legislature felt that they had to call a state nullification convention, and they passed the Ordinance of Nullification in 1832. And President Jackson, who saw this as tantamount to treason, was ready to use military force, and South Carolina raised its own force and was ready to secede from the Union. And it's sort of both a heavy-handed and a diplomatic measure. Congress passed the force bill to allow Jackson to militarily enforce the federal tariff to reinforce the power of the federal government, especially the executive branch. But at the same time, they passed the compromise tariff that would gradually reduce tariff rates over time. But this crisis laid the groundwork for the excuses that the South would use to secede from the Union at the beginning of the Civil War. They saw tariffs as just one way that the federal government was infringing upon states' rights and the Southern way of life. And so you saw this as one of the key ingredients to slavery and the outbreak of civil war, because states' rights were used to justify slavery. But what a lot of people don't realize is that it was also used to excoriate slavery. On the pro-slavery side, they said that the federal government had no authority to ban the expansion of slavery, and they claimed that was discrimination against slave-owning states, because at the time, many people tried to balance the level of power between slave-owning states and free states being in the north and slave-owning states being in the south. And they felt that it was infringing upon states' rights to prevent these states from their constituents recapturing escaped slaves. And they also cited how slavery was not fully erased from the U.S. Constitution. On the anti-slavery side, though, they noted the inconsistency of the South when it came to these states' rights philosophies, where they pointed out, for one thing, the gag rule in the U.S. House of Representatives, which was from 1836 to 1844, and that banned not only trying to get rid of slavery, it banned even bringing up the issue of slavery. You just could not say anything about it at all because of how many heated arguments it had brought up, and in some cases, violent conflicts even between sitting congresspeople, like how Charles Sumner was beaten by Preston Brooks with a cane, Charles Sumner being vociferously against slavery and lambasting slave owners, and Preston Brooks took it upon himself to beat him unconscious with his cane. And the North also brought up how the fugitive slave law, which compelled northern states to return escaped slaves to the South, infringed upon the states' rights of the North, saying that, well, why do states in the South, why do their interests supersede any in the North? If they come into our borders, why should we return fugitive slaves? And these arguments over slavery led to many attempts at compromise, but one particularly notable attempt at compromise in the vein or in the realm of states' rights was the idea of popular sovereignty, which said that states should decide for themselves, territories who are becoming states should decide for themselves whether or not to be a free state or a slave state. And this popular sovereignty idea was most prominently championed by U.S. Senator Stephen A. Douglas, who was the other participant in a particularly famous debate featuring Abraham Lincoln before he became president. And so this idea of popular sovereignty was put to the test with the Kansas-Nebraska Act, which let these territories decide for themselves whether to become free states or slave states as they went through the process of becoming states. Nebraska didn't really have too much trouble becoming a free state. Kansas, on the other hand, saw 4 proposed state constitutions and considerable bloodshed during the period known as Bleeding Kansas. You saw pro-slavery border ruffians launch a series of violent acts and intimidation tactics and electoral fraud to try to make Kansas a slave state, which included the sacking and massacre of the town of Lawrence. Meanwhile, anti-slavery Jayhawkers retaliated with violence as well, including the Potawatomi massacre. And you saw, even after slavery was eradicated with the 13th Amendment, with the rise of Jim Crow in the South and the Civil Rights era, you saw a lot of these similar arguments for slavery being made for segregation. Even though slavery was outlawed, Jim Crow was an attempt to basically recreate the conditions of slavery without actually calling it slavery and without technically enslaving human beings. This idea was that it was the states' rights in the case of the South, to administer these laws for their society in such a racist way. Another key development in the states' rights, in the history of states' rights, is the incorporation of the Bill of Rights. And what the Incorporation Doctrine refers to is the application of the Bill of Rights to the state governments. Because in early American history, the Bill of Rights was narrowly applied. actually only to the federal government, not to the states. And one key example of that was the Supreme Court case of Barron versus the City of Baltimore in 1833. And so states were much less beholden to the core values that we hold dearly from the Bill of Rights, like First Amendment freedom of speech and religion. Although some states had some similar laws to the Bill of Rights, they had a lot more leeway as to how broad or specific those rights could be. But this legal precedence started to change drastically following the ratification of the 14th Amendment in the late 1860s, early 1870s. The 14th Amendment said that no state, or it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And so it was through this due process clause, parts of the Bill of Rights, the first 10 amendments, started to be applied to state governments. But the amendments have different levels of incorporation in applying to state governments, according to Cornell's law school. Cornell says that full incorporation happened for the First, Second, Fourth, and Eighth Amendments. So, First Amendment being religion, freedom of religion, speech, press, assembly, and petition. Second Amendment for bearing firearms. The Fourth Amendment, which protects against unreasonable searches and seizures, and the Eighth Amendment, prohibition of excessive fines and cruel and unusual punishments. Those were fully incorporated to apply to the state governments, not just the federal government. But a couple of amendments have only been partially incorporated, and those were the Fifth and Sixth Amendments. So the Fifth Amendment, with its exception for the right to indictment by a grand jury, and the Sixth Amendment, except for the right to a jury selection from residents of the crime location in a criminal case. And then, in the case of the Third, Seventh, and Ninth and 10th Amendments, those have not been incorporated at all. The Third Amendment, which prohibits forcing a homeowner to provide shelter to soldiers. The Seventh Amendment, which provides the right to a jury in civil cases. Those have not been incorporated at all. The Ninth Amendment, which grants any rights not expressly stated in the U.S. Constitution to the people, that is rarely ever relied upon in SCOTUS cases, in Supreme Court cases. And then the 10th Amendment applies directly to the states because it's any powers not given to the federal government belong to the states. So you can't really incorporate that because it is directly applicable to the states. And for the last major development in regards to states' rights that we'll talk about here is the development of federalism. So, for about the first 150 years of the United States under the Constitution, we had what is called dual federalism. It's imagined like a layer cake because the federal and state governments had mostly distinct spheres of authority. And like in a layer cake, there's distinctly one flavor in one layer, and then another layer, there's a distinctly other flavor. But from the New Deal to the 1960s, you saw a lot more of what is called cooperative federalism, which was ushered in by Franklin D. Roosevelt's presidency with the New Deal. And this had federal and state governments mostly intertwined and working jointly, especially in the realm of commerce. But from the 1970s to today, you see a lot of people have taken to call new federalism, or an era of devolution, where there's been a shifting of power back toward state governments and more clear demarcations of authority between federal and state. And one way you see that is through the use of block grants that have been used by presidents like Richard Nixon and Ronald Reagan, where sums of money are given to states and local governments to determine more for themselves where to spend the money, whereas some grants are specifically, you have to use it for this particular purpose, like for roads, for example. In the cases of Nixon and Reagan, and sometimes with some other presidents, they've been more general as to what they could be used. They basically tell states and local areas to use this money where you see fit. Now, of course, those are not clear-cut, like there's never cooperative federalism anymore, or there was never dual federalism during the era of cooperative federalism. That's not what that means. But the prevailing concept of federalism, you saw dual federalism for the first 150 years. From the 1930s to the 1960s, it was much more cooperative. And from the 1970s to now has been sort of moving back more towards that dual federalist concept. So that leads us to today, states' rights and today's politics. People sometimes pick and choose when to support states' rights depending on if it benefits them. If your party is in power in the federal government, tend to be less supportive of states going a different way, or at least the concept of states' rights is considered differently. And if your party's out of power, you tend to be more supportive of states' rights because you want states to be able to go against what the current ruling party in the federal government thinks is the correct policy. And a recent development in this states' rights debate is the Anti-Commandeering Doctrine, which says that federal government cannot compel states to directly use state resources to enforce federal laws or programs. Federal law is still supreme, but the federal government has to use its own resources to enforce those laws. They cannot tell states they have to do it. Now, states can willingly abide by that, and we've seen that over and over again. Right now, we've seen more Republican states be more acquiescent to the federal government because the federal government is run by the Republican Party right now. But when it was the Democratic Party that was in charge in the federal government, you saw more Democratic states acquiesce to the federal government as well. But there is some debate as to how much of it really is the federal government letting states decide whether to comply or use their own resources to comply with federal government or not, and how much of it has been coercion or pressuring of state governments to follow federal guidelines. So 4 salient issues that we see in particular when it comes to states' rights and the states' rights debate are immigration, abortion, LGBTQ policy, and religious expression. They're not the only ones, but you see states' rights and whether or not it is a state purview or a federal purview, you see that crop up a lot in these issues. In the case of immigration policy, you see states' rights crop up a lot when it comes to what conservatives call sanctuary cities. ICE deployment, immigration enforcement grants from the federal government given to states and localities. In the cases of sanctuary cities, there's a lot of debate about whether the federal government can force these state and local governments to basically give up these immigrants, or whether they are actually housing these immigrants who are, depending on your verbiage, we call them illegal versus undocumented. But for some people, they see that as an infringement on states' rights because the states have to decide how to deal with these immigrants, whereas federal government or people who are against the states' rights view, at least in the case of this, say that federal government is simply just upholding its own laws. In the case of ICE deployment, it's a similar thing. Is the federal government intruding on states' rights by deploying ICE federal immigration agents into state areas to try to basically enforce or to force states to comply with federal immigration policy? And you've also seen a lot of enforcement grants provided to certain states and localities, especially ones that are more aligned with the Trump administration. Some people see that as another way that federal government is overstepping its bounds. In the case of abortion, the overturning of Roe versus Wade in the Dobbs versus Jackson case, which returns abortion to being an issue that the states decide. Now, is that a states' rights situation? Should abortion be decided by the states, or is it protected by the 14th Amendment? LGBTQ policy. And this is a pretty large umbrella, but for one thing, opposition to the Obergefell versus Hodges case. For a lot of people, they say that's an incorrect reading of federal power given by the U.S. Constitution, that gay marriage and other similar policies should be left up to the states, whereas other people will say that it's a 14th Amendment issue, and so the federal government's power supersedes the state government's power in this case. And there's also concerns about the Supreme Court possibly reversing the ruling of Obergefell versus Hodges in a future Supreme Court case, similar to what happened with Roe versus Wade in the Dobbs versus Jackson case. And then lastly, with religious expression, you see things like putting the Ten Commandments outside state government buildings or making the Bible required reading in schools. Is this states' rights? Now, you might talk about the Incorporation Doctrine protecting religious expression, but for some of these states that are making the Bible required reading, for example, or putting the Ten Commandments outside of state government buildings, they're saying that this is within state purview, that it's not forcing people to believe something, but it's also that the states should be able to dictate these kinds of things, that they're actually protecting religious expression by doing this. So there's a bunch of different ways that this can be looked at, and just wanted to give a basic overview of these policies. Unfortunately, don't have enough time to really hone in on these particular issues, and really wish I could go much more into it, but unfortunately can't right now. So I wanted to make sure I got this out here. But that's going to do it for today's episode of the Politics with Paul podcast. As always, thank you so much for listening. Please like, comment, share, subscribe, and my links are in the show notes. My other works, including my Medium.com profile, my 5-day educational email course about how we can more effectively tamp down toxicity and polarization and mitigate it, my book on political independence and why they struggle so much in elections and how they could potentially reverse said fortunes, not arguing that we should or shouldn't have more independence, but wanted to give much more of a view on something that is not very well understood. And then my other links, my Facebook, my LinkedIn, my website, and my email, paulraderwrites@gmail.org. So, as always, thank you so much for listening, and we'll see you next time.